All right, so we're here at entry 4. This is Tuesday, February 25th, 1964. This diary entry is about 1.5 pages. Let's set the scene for us, what this is about.
Well, I think the principal issue discussed in this entry is whether the commission ought to enlist the assistance of the American Bar Association in our investigation so as to provide some protection for the civil rights of the deceased assassin. There had been complaints raised early on by Mark Lane, among others, that the commission should have hired an attorney for Lee Harvey Oswald, and of course Mr. Lane suggested that he was the best qualified candidate. He had become an early and a frequent critic of the commission's work, and was initially wrote articles contending that there were at least 2 assassins, that Oswald did not kill Officer Tippit, that there was other people shooting, and that Oswald was being improperly accused of a crime that he had nothing to do with. And based on his brief on behalf of Lee Harvey Oswald, he became counsel to Lee Harvey Oswald's mother, Margarita. And he went around contending he had information that was of relevance to the inquiry. But on this point, he basically was saying that the commission is ignoring Oswald's rights, for example, to not have his wife testify against him, and that he was being subjected to unreasonable questioning at the police department and so forth and so on before he was killed by Ruby. So the commission had denied his request to serve as counsel to the deceased assassin, but beyond Lane, there were others who were seeking at least some commission response to these concerns. The American Civil Liberties Union, for one, was suggesting that the commission should at least be careful in its proceedings so as to recognize that if Oswald were alive, he would have some rights which at least the commission should pay deference to. And indeed, because of that fact, Rankin asked Sam Stern, aided by one of our new associates, John Ely, who was a Yale Law School graduate and scheduled to become a clerk to Chief Justice Warren in the fall of '64, to come on duty and help. And so Rankin asked Sam Stern and John Ely to address Oswald's treatment by the police department. You know, was he properly brought before an authority to hold him in custody? Or was he given his right to hire counsel? How was he treated with respect to questioning, and so forth and so on? And so Rankin responded of his own initiative to this kind of concern by authorizing such a memo, which we did, I believe, discuss briefly in the final report. But beyond that, members of the staff generally did not think that bringing in anyone from the ABA was really going to properly address these concerns, because, in fact, they could not be addressed given the death of the assassin. And what the staff also felt was that they were there not as prosecutors, they were there to lay out the facts, and they were not there in a way that would threaten any rights of Lee Harvey Oswald. Whenever that point's made, however, the commission would have to state, but yes, we did accept the testimony of his wife when she testified that he told her that he had tried to kill General Walker. I mean, that was an admission of a kind that could not have been made in open court if Oswald were being tried for the murder of the president. So, but the American Bar Association, you know, obviously was an establishment organization with a natural conservative bent, and so from an ACLU perspective or a Mark Lane perspective, the ABA was perhaps the least qualified among available organizations to guarantee a fair treatment by the commission. So there was that tension, and I personally was, as were many members of the staff, somewhat surprised and offended by the concept that the commission needed some independent outside organization to confirm that the investigation we were conducting and involved in did not meet all the professional requirements, ethical and otherwise, due under these circumstances. So after I wrote a long memorandum to Nick Katzenbach about this, leaving it up to him to decide whether to intervene, because the situation became complicated once the ABA told Rankin that it's the head of the ABA, Walter Craig, would be the representative from the ABA to the commission to serve this function of overseeing the commission's work, aided by such associates as he wanted. And of course, the last thing I wanted was to have a team of associates come in to begin to investigate all that we had already done to date and what we plan to do for the future. But what Rankin didn't know, and what I didn't know, was that Craig was going to be the selection, and that he had already been designated and confirmed to be a district court judge. And the Deputy Attorney General wanted Mr. Craig to proceed immediately to his new judicial position, and had obtained from him a commitment not to take on any additional responsibilities. So the Deputy Attorney General, shall we say, was somewhat displeased with the Commission's engagement of Mr. Craig, and his lack of enthusiasm or displeasure was troublesome to Rankin. And I was troubled by it, because I could have done more to raise this issue if I had known that the ABA was going to select Craig. Then I could have brought the problem to Rankin and to the deputy's attention earlier, but I'm not sure that would have changed the appointment. In any event, that's more than you wanted to know. It was something that seemed like a major issue at the time, but over time disappeared, because Craig and people did show up apparently. They asked for documents occasionally. They asked for draft versions of the report occasionally. And at the final point, it was basically just sort of a general seal of approval on our operation that didn't either please or displease anyone very seriously.
Yeah, I was going to say, I don't think Walter Craig appears anywhere else in the journal, so it's clear he didn't play a significant role. You did mention, since you mentioned the investigation that Stern and Ely did into Oswald's civil rights under the custody of the Dallas police, can you give me just the broad strokes of what their conclusions were? Were his civil rights violated?
No, the conclusions were pretty favorable to the police department and then the district attorney's office, both in terms of access to telephone to hire new counsel, and the bail bond procedure, and all the other procedures. I guess what was not in this major civil right violation, of course, was failing to supervise him sufficiently so he wasn't killed. To be blunt about it, and the second less important issue on which they failed, that may not be a civil right issue, was to parade him in front of audience of reporters and onlookers, including Jack Ruby, when he was being moved from room to room in the police department. The Dallas Police Department, it turned out to our surprise, had a affirmative policy of being open to news reporters. And however commendable that might be under many circumstances, when you had a person charged with the assassination of the President of the United States, there was considerable risk in not observing every possible protective measure to protect assaults against him or other unseemly conduct by anyone in the room.
I think that pretty much covers entry 4, unless there's anything else.
No, that's fine.
Okay.